Good morning. Um, okay, I have a number of positions on the calendar. I probably think we're going to move through them fairly quickly with just some announcements, but we'll see what we have. I'm just going to call the calendar, figure out where everybody is, what everybody's doing, and figure out what we need to do next. I do have one matter. I'm just going to go ahead and warn everybody. I think I'll get to it fairly quickly, but the um, emergency hearing that I have scheduled in Fulton County School District versus SC. I'm that's going to be the one that I expect to take the most of my time. So, for those of you who are here for that one, if you'll just sit tight, we'll get started as quickly as we can. And with that, let's get started. State Farm Casualty as subrogate of Charles Gibbs versus Marta and Derek Kelsey. Who do I have?
Good morning, Your Honor. Keisha Townsend here for the plaintiff.
Hi, Ms. Townsend.
Roosevelt Hand for the defendants.
Hi, Mr. Ham. So are y'all really going to go to trial over this property damage subrogation case?
Well, that's up to Roosevelt. We have gone to mediation. It was unsuccessful. We were pretty close, but we just couldn't make it happen. So it's really what Marta wants to do, but we're ready to go.
Mr. Ham?
Your Honor, we made good faith effort to mediate this case. We made good faith offer. It takes two sides to come to an agreement. We're open for any further negotiations, but if necessary, we can go forward with a trial.
Okay. Well, I didn't mean to re-invite any, re-argument or whatever. I just,
No.
commenting on the fact that obviously all comers, the court will entertain whatever I need to do, but it is a lot of resources to be expended for what seems to be a relatively small claim. Just my comment. Couple of things to note real quickly. Technically, this was on for a pretrial conference. My review of the file is that there is not a jury request. And even if there was a jury demand, it would have been waived by, I don't believe I've been provided with a consolidated pretrial order. Not to say that anyone was supposed to have, if that was a conscious decision, just that in my standing case management order says this will then therefore proceed as a bench trial. So one question I do have in order to get it scheduled is everybody ready? Assuming that, further efforts at settlement have not succeeded or are not expected to. How long do you think it will take? Ms. Townsend?
Oh, probably an hour and a half. I mean, it wouldn't take too long.
Okay, Mr. Ham?
I would agree with that assessment.
Okay, from each or total?
I would only have 3 witnesses, so I think probably 2 hours total.
Okay, that's fair. Okay. And do y'all have a strong opinion either way as to if this case now, generally speaking, I do a lot on Zoom. But generally for trials, I would have those conducted in person, even bench trials, just because the presentation of evidence gets a little clunky by Zoom. Just want to make sure y'all know that this would likely be something I would have you come in one morning, specially set at the end of August, so that we could, handle the matter. I mean, it is technically on the August calendar. This is the pretrial for that last week of August. Any thoughts, concerns, issues with availability I should know about before I send out some sort of notice letting you guys know?
No, Your Honor. I think we're good to go.
Okay, Mr. Ham?
I would agree, Your Honor. I think we're ready to proceed whenever we're called to do so.
Okay, excellent. Well, I can tell you, just to make your lives a little bit easier, in terms of giving you some insight, the criminal trial calendar the civil trial calendar for August is set to go the week of the 26th of August. And so what I'll do first is figure out if I have any civil jury trials that are going to go. If I don't think I do, but assuming that I don't, what I will do is pick a morning that week or probably just email y'all and say, hey, what's a good day that we could all get together for a few hours and take care of this? And it will be sometime that week of August the 26th, just to give you a heads up. So if you guys want to go ahead and even email me and say, hey, these 2 days are better than these other days. And I said morning, but I'm also open to the afternoon, whatever works for everybody, just so we can go ahead and get it accomplished. Okay.
All right. Thank
Yes,
you.
Your Honor.
Thank you. You both may be excused unless you need anything else from me, Ms. Townsend.
Yep, that's it. Thank you.
Mr. Ham?
Nothing further, Your Honor. Thank you.
Excellent. Have a good day.
All
Thank
right,
you.
bye.
Citibank versus Richard Lenartz.
Monique Greenidge here on behalf of the defendant.
Okay. Do I have anyone here on behalf of Citibank? Mr. Freehoff, will you check and see if Citibank has submitted anything to us or emailed you indicating that they were or were not going to be present?
I will confirm that, although I do not believe I have anything from them.
Okay, Ms. Greenidge, it is 9:06. I usually give them a little bit of time to show up to see if they're going to show up. But these are set as peremptory calendars, and so if they don't appear, the court reserves the right to dismiss the case. So if you'll sit tight for me and wait and see if somebody appears on behalf of Citibank, we'll go from there. Okay.
Sounds good, Judge. Thank you.
Thank you. American Express versus Zulon Berry.
Good morning, Your Honor.
That's all right.
Tara
Christopher
Gardner
Dewan.
here on behalf of American Express.
Okay.
Christopher Dewan, part of the defendant, Your Honor.
And on behalf of Mr. Berry or Ms. Berry, I don't know if that.
I think it's Blake. I'm mistaken.
Oh no, that's a different one. I'm not there yet. I'm on
I apologize,
Amex
Your Honor.
versus Zulon Berry. That's okay. Do I have anyone here that is Zulon Berry or here on behalf of Zulon Berry? Okay. Ms. Gardner, same message. If you'll sit tight, I will see what happens. Have you had any contact with the defendant, Berry? I know the other defendant was voluntarily dismissed.
It does not look like we have had contact with Zulon Berry. And
Okay. Okay, thank you. I'll come back to that towards the end of the calendar. Next up is American Express versus Chris Arnold.
Tara Gardner here for the plaintiff. We actually have resolved this. We have a consent judgment, and I was hoping to get Mr. Arnold's email address so that we could email him that consent judgment.
Excellent. Mr. Arnold, I see you on the Zoom. Is that your understanding as well that y'all have worked something out?
Yes, Your Honor.
Okay. Mr. Gardner, I'm sorry, Mr. Arnold. I don't know how fluid you are with Zoom. Do you know how to use the chat?
I can send her over my email.
Okay, excellent. If you'll do that, once y'all confirm that y'all have good contact information for one another, then it'll just be a matter of getting that consent order to me once it's signed and approved, and I'll get it on file for you, okay?
Yes, thank you.
Thank you, but then as soon as
Thank
you share that information, you're free to be excused, Mr. Arnold.
Thank you.
American Express versus Zanaya Blake.
Christopher Dewan for the defendant, Your Honor.
Okay, and is there anyone here on behalf of American Express?
This is not on my list, but I'm not sure who the law firm.
I have listed Louis Feingold.
I'm not with that firm.
Okay.
So I cannot announce for them, but I could get in touch with him and let him know that this is on for today.
Okay, well, it may not matter, Mr. Dewan, because when I was preparing for the hearing last night, reviewing the case, what I discovered is that this really shouldn't have been placed on the calendar. I know there's minimal discovery. The court entered its own scheduling order because the parties did not. But even according to my own scheduling order, discovery doesn't run until August the 23rd. And the dispositive motion deadline, which oftentimes resolve these cases, doesn't run until August the 30th. And so it was actually premature of the court to place this case on the calendar. And so for that reason, we were intending to reset that case to a later calendar that honors the scheduling order that the court itself entered. So I apologize for taking up your time, Mr. Dewan, but we will send out another notice. I believe the idea was if the dispositive motion deadline is August the 30th, that it would likely be called in September. And so if you can, we'll send you a notice, but you can expect that you'll probably be called in September. Okay.
Yeah, thank you, Your Honor. May we excuse?
Yes, sir. Thank you.
Thank you. Thank you.
Okay, After Nine Partners versus MetaWorks.
Frank DeMelfi on behalf of After Nine.
Hi, Mr. DeMelfi.
Good morning.
Yehuda Brock on behalf of MetaWorks and Scott Gallagher. Good morning.
Hi, Mr. Bruck. How are you?
Good, how are you?
I'm doing fine, thank you. And this I have down for a motion for default. Is that correct?
Yes, Judge.
Okay. How long do we think that's going to take to discuss? Mr. DeMelfi, I think it's your motion, correct?
5 minutes from my side, Judge.
Mr. Bruck, response?
5 minutes from my side.
Okay, great. Thank you. Cook's Landing Homeowners Association versus Nisa Green. Do I have anyone here on behalf of Cook's Landing Homeowners Association? Mr. Freehoff, can you check and see if anyone in that case has opened the notice of the hearing or reached out to you to indicate they were planning to attend?
Yes, Judge, I will look into that.
I'm here.
Oh, Ms. Green?
Yes.
Okay, thank you. And so we're gonna, Ms. Green, as you heard me say to some other people weren't here. I'm gonna give a little bit more time to see if someone appears, and then I'll let you know what we're going to do from there, okay?
Okay.
Citibank versus Bryant Johnson.
Claim right on behalf of Citibank.
Mr. Wright?
Yes, Your Honor.
Okay. And have you had any contact with Bryant Johnson? I know it's a default hearing, but had you had any expectation that that person might appear today?
No, Your Honor.
Okay. And let me guess that it'll take you, what, 5 minutes to present your default motion?
Yeah, 5 minutes or less.
Okay, thank you, sir. Okay, and then Vatav versus Canopy Workforce Solutions.
Yes, Your Honor. Blake Fry for defendant, and we have reached a settlement agreement in principle. We just reached yesterday. So, and we were not able to get the notice of settlement on file before this conference, but we should get that on file today. And then we just need time to complete the settlement paperwork. But
okay. Happy to allow that. I'm glad that you resolved the case. Mainly it's just that my experience has been when parties say we've worked out an agreement in principle, that sometimes 3 months go by and I don't get a dismissal order or whatever. So Mr. Vatav, is that your understanding as well, that there is an agreement in principle that the parties simply need to reduce to a formal written agreement?
Yes.
Okay, excellent. So if you could file some sort of, bare bones notice of settlement that the parties have reached an agreement in principle and that you need until X date or however many days you need to finalize that settlement, and then submit that in Word format so that the court will be able to enter something that will tell it, hey, we know when to look again to expect this case to actually be dismissed as a result of the settlement.
yes,
Okay.
Your Honor, we can do that.
Thank you so much, Mr. Vatav and Mr. Fry. I appreciate you showing up, and I'll look for your notice of settlement, and then good luck with resolving, getting all the T's crossed and the I's dotted.
All right. Thank you, Judge.
Thank you both. Have a good day.
You too.
And Fulton County School District versus SC. Who do I have here on behalf of the school district?
Your Honor, Bennett Bryan and Ashley Akins on behalf of the school district.
Okay. And who do I have on behalf of SC?
Good morning, Your Honor. Randy Waldman on behalf of SC.
Okay. So I couple things. One, can I get a time announcement from you guys? And I know in order to get a time announcement, there was at least some indication that y'all felt that I hadn't been as clear as perhaps I should have been about what was going to be addressed at today's hearing. I understand that the case is very new and relatively premature for a full-blown hearing on the merits of whatever it is, given there's some dispute about what's the appropriate procedure to follow and what's the appropriate substantive law to apply. What I will tell you is what I saw was a student who is not in school as a function of this dispute, and a concern that needed to be addressed in the short term while the parties address the larger issue. And so that was the court's intention. What are your thoughts on that, Mr. Bryan and Ms. Akins, regarding how long it might take you and your ability and preparedness to address that issue today for the court?
Thank you, Your Honor. That was what we were assuming what this hearing was going to be about today. Because we're really here on an emergency motion from the other side, part of our time will depend on, the issues raised on their opening argument, but I would say 15 to 20 minutes. I mean, this is pretty much just a legal argument that requires, basic application of statutory interpretation principles.
Okay, excellent. Ms. Waldman.
Yes, Your Honor, probably the same. I would have originally guessed 20 to 25, depending upon, I suppose, Your Honor's questioning within the middle of that.
Okay, excellent. And do you have a court reporter?
We do not, Your Honor.
I mean, that's fine if you don't have one. I just want to let you know that the court does not provide a court reporter for civil matters. And so if you wanted it taken down, y'all just needed to have arranged that for yourself, which I think is in my notice and also in my standing case management order. Okay.
Understood, Your Honor. We were not anticipating a takedown.
Okay, that's fine. Thank you so much. I am going to circle back to my other cases. It'll just take a few minutes. It's 9:17. I suspect I'll be back to you guys at about 9:30 and ready to actually take that matter up substantively. Okay. Ms. Greenidge.
Yes.
Do I have anyone here on behalf of Citibank in the matter of Citibank versus Richard Leonards?
Judge, I can tell you that eFile Georgia shows that a quote unquote service email, which is used as the contact for plaintiff's firm, the Flynn LeVar firm, opened this notice on August 5th, 2024. So we have to assume that plaintiff's counsel had notice of this hearing.
Okay, and they are not here. Ms. Greenidge, thoughts?
I would move for a dismissal.
Okay. We will be dismissing this matter for failure to prosecute. And we'll get an order on file sometime later today, Ms. Greenidge. Okay.
Sounds good. Thank you, Judge.
Thank you. Have a good day.
You too.
American Express versus Zulon Berry. Ms. Gardner, are you still with me?
Yes.
Okay. I still don't see Mr. Mr. or Ms. Berry.
Judge,
Yes.
Zulon Berry has a contact in eFile Georgia as an anonymous kiosk. However, Section 4F of the court's standing order on e-filing says that he has to have a valid email address. And if he doesn't, quote, to qualify for non-electronic service, the self-represented litigant must make a certification in his or her initial filing that he does not have an email address and therefore cannot register for an eFile Georgia account. However, I investigated further. Mr. Berry has once emailed me, so he does have a valid email address and did not include it in his eFile Georgia contact. And as a result, he didn't get notice of this this default matter, but it is technically his fault that he did not.
No, I think it is a pretrial matter.
Oh, is it? Okay.
Yeah, I think.
Oh, yeah, that's right. He filed an
Mr.
answer. I apologize.
Berry
It's a
filed
pretrial
an
conference.
answer.
Yeah.
Ms. Gardner, what are your thoughts?
We would request for his failure to appear that the answer be stricken and enter judgment by default.
I feel like even though it is Mr. Berry's fault, I feel like I need to give Mr. Berry one more bite at the apple of this matter. This was a pretrial conference, and so it was set to be heard at a trial the week of August the 26th. I think what I'm going to do, I know I have a calendar that week. I think I'm going to add this case to that calendar and make sure that we have a record that we sent notice of this matter to Mr. Berry's email address that we have. And that will give me some solace that Mr. Berry did in fact know about the case. I suspect he probably does, because if he was able to access Odyssey, he's probably able to access the system at least to see. But I do want to make sure that that the court provided the notice that Mr. Berry is entitled to. So I'm going to reset this for the week of August the 26th. We'll send out a notice and make sure that it's emailed to Mr. Berry's email address, and then we'll go from there. Yes, Mr. Freeman.
Judge, I wanted to give you the option. We do have a default calendar on Friday, August 16th, if you'd like to hold the pretrial conference earlier than the last week of August. And I can get notice out to both parties today, immediately following this hearing.
Yeah, that'll be fine. Ms.
Okay,
Gardner,
so-
does that work for you?
Yes, so reset to August.
August the 16th. We'll send out that notice today.
And that'll be on the default calendar.
Yeah, I mean, it's
Not a
still
trial.
set for a pretrial conference, but it will be on the default calendar.
Thank you, I appreciate that.
Thank you, Ms. Gardner.
And
then,
That's all I have, maybe
yep.
excuse.
Yes,
Thank
you may. Thank you very much. And let's see, After Nine Partners LLC. Mr. DeMelfi and Mr. Bruck. Okay. So let me start by saying that I was saddened to see such a clear miscommunication between two very capable attorneys. It appears to me that there's no dispute that a conversation was had on the day that the answer was due, and that the parties came away with very different understandings of what resulted from that conference. That's my general understanding right now, because I do want to make sure that disabuse me of this notion, but we are talking about a one-day. The parties had agreed that it would be due on June the 3rd, and ultimately the answer was filed on June the 4th. Is that correct, Mr. DeMelfi?
That's correct, Judge.
Okay, excellent. Okay. Go ahead, Mr. DeMelfi.
Well, Judge, I mean, it comes down simply to, I think you said, like potentially a disagreement or a misunderstanding between the parties. However, the fact of the matter is no stipulation or consent motion was filed to extend time. The answer was filed late. Defendant did not move to open the default motion as a matter of right within the 15-day time frame and didn't pay costs. This was the fourth time we've provided the defense an extension, and in Your Honor's last order extending time, that would say Your Honor said that there would be no additional extension provided. The fact of the matter is the defendant, through no fault of opposing counsel, had ample opportunity to secure counsel on time, to secure answer before the answer was due, and had an opportunity to file it before the answer was due. So, for that reasons, procedurally, the answer wasn't valid because the case at that point was in default.
Understood. Mr. Bruck, your response, sir?
Yes, so a few things. The reason why I filed the exhibit of my screenshot is because I wanted the court to notice that this call was to Mr. Melfi's private cell phone at about 7 p.m., a few hours before it was due. Mr. DeMelfi says that the conversation was about the case. Now, the only reason why I would call his cell phone, his personal cell phone, at night, right before the deadline is due, is to discuss an extension, which he concedes I did. He says he offered me 10 days. He's in his motion, he says he offered me a 10-day extension that I declined. Well, that is true. I declined 10 days, telling him I'm going to file it tomorrow. And the call lasted less than 6 minutes, so it wasn't the conversation about the case. I introduced myself, told him I practiced for 20 years in Florida. I recently moved to Georgia. Can I have the extra day? If he would have said no, I would have filed it. But he said, sure. I'll give you even 10 days. And that's the first time I heard the name Freehoff. He said, well, we'll send an email to Mr. Freehoff and we'll tell him that we reached an agreement for 10 days. I said, no, not necessary. I just want to stop working now. I have my wife and 2 kids in the house. I'm in the driveway. I'd rather do this in the morning. And he said, well, far be it from me. He said, don't worry about it. If you're going to file it tomorrow, I won't file a default. Just file it tomorrow. I'm sure the default won't be entered by tomorrow. They're usually not that fast. And then, I didn't file a motion with the 15 days because I had no idea that there was a default. I thought I had complied, and yeah, right. So I didn't move to open it because I didn't know it was closed. But the minute when I found out that, and I really don't understand how this miscommunication could have happened. My wife's a lawyer. I came in the house and I said, hey, I can stop working. I can help you out. What's up? Because I got a day extension. The minute I found out this is going on, I was about to pick a jury in a murder case in Florida. The minute I called the clerk's office, they said, no, you have to pay the money in person. I went to the Fulton County Courthouse right when I got back, and I did what I needed to do by, make a showing under oath to plead it right away, and now it's ready to trial and a meritorious defense. But there's no precedent that I could find for entering a default where there's a misunderstanding of an attorney and an affidavit under oath that this was my understanding. And I don't think, and I think the context of the call, both the time of the call, the length of the call, the fact that Mr. Melfi offered 10 days, indicates that my understanding of what happened is such that that was the state of the world. That's the most I'll say about that.
Okay. So, Mr. Bruck, I will tell you that you have fallen headlong into, one of my favorite tasks as a judge is swearing in lawyers who come from other states. Because I went to law school here in Georgia, but then went to practice in Florida. And one of the things I discovered when I came back to Georgia to practice meaningfully is that Georgia's default rules are unique. And one of the things that the one thing I do when I swear in lawyers from other states is I refer them to 9/11/55, and I recommend whatever side they represent, if they do civil litigation, to familiarize themselves with that statute. And I suspect that that's what's happened here. And so here's the issue. In spirit, I completely agree with you, Mr. Bruck, that it sounds to me as if the most likely scenario here was that Mr. DeMelfi acceded or, whatever, whether it was an affirmative agreement or not, but, hey, fine, whatever, if you're going to file it tomorrow, file it tomorrow. But unbeknownst to you, if you don't file an answer, the default is automatic. But it can be opened automatically within 15 days. And you didn't do that. But here's the thing. I agree in principle that you filed an answer one day late. But Mr. DeMelfi's right. You haven't followed the procedure. However, what I will say is this. While you could have opened as a matter of right, you can still move to open at any time. But there's a procedure that has to be followed if y'all want me to consider opening that default, and that procedure has not been followed.
I did. I paid the fee and I filed the motion to the right away, like I told the court, right away when I found out that Mr. DeMelfi is claiming that there's a default, I went to the clerk's office, I paid the fee, and I filed the motion to set aside or vacate the default.
Okay. When did you file that? Because or maybe it's got a weird name because I'm not seeing such in the docket.
Judge, I see that docket number 16, the clerk has labeled it as an answer, but it is titled Response to Motion for Default.
Right.
Oh.
It's a response. It has a longer title. Response to motion for default to vacate the default or set aside the default.
Okay. So.
And there I fulfilled the 4 requirements of setting aside the default. My understanding was that would be heard this morning, but I mean, if it can't be heard this morning.
No, the case is on for a request for default. And if there's a motion to open the default, then it's also on for that. Right. It's just that sometimes the way that things get entered into Odyssey make it difficult for me to understand that that's what was filed. Okay. So your position is that you have satisfied the requirements of 9/11/55 to open the default and avoid a default judgment by paying costs, pleading in stanter, providing excusable neglect or proper case justification, et cetera. Is that right, Mr. Bruck?
Yeah. Yes, and I pled all that in the pleadings and then some. There's a few other arguments. I regret that my final draft didn't make it to the filing, so there's a few errors there, but it's substantively the same. There's just a few copy and paste errors, but yes, it's all there. All the 4 requirements are there.
Thank you, Mr. Bruck. Mr. DeMelfi?
Judge, I don't think he satisfied the aspects of the to move to set aside. I mean, this wasn't a case of. It's a case of counsel not knowing the law, not following the law, not following procedure, is what it is. I disagree with the conversation that we had. I'm not going to get into that in the back and forth, but I think it stands that the answer was filed late. There was nothing done within the 15 time frame, and therefore the case is in default.
So, Mr. DeMelfi, I agree with you that the case is in default, because it was automatically in default, but I have not yet entered a default judgment. And what's required under Georgia law to avoid the entry of a default judgment after default is to set aside the default, based on the appropriate showing. It does appear from a brief review, that Mr. Bruck has asserted, has satisfied the 4 requirements in terms of assertions of, you know, the pleading and stanter, verified, et cetera, unless you're going to tell me that your review of it is different. And really, if that's the case, if he's satisfied all those elements, then the only thing left for the court to do is determine whether or not he's satisfied allegations of excusable neglect or a proper case. And generally speaking, proper case, I think the case law says, is the most broad. It literally empowers the court to reach out and accept anything that would further the interests of equity and justice. Based on all of that, I think that Mr. Bruck has satisfied, has successfully requested that the court should set aside the default that occurred when the answer was filed on June the 4th and not on June the 3rd. And so what I will do, Mr. Bruck, if you could please provide me with a proposed order that grants your request to set aside the default, that denies the motion for default judgment that was entered, that was filed by the plaintiff, and accepts the filing on June the 4th of the answer as having been timely filed.
Your Honor, just one thing, at the risk of exposing my ignorance, I'd ask if Mr. Fioff can send me a sample order for this court. I never practiced in front of you, and I don't know what the requirements would be.
Okay. I don't know that he has a sample order to send you. It really is just.
Judge, I can help out there.
Thank
All
you,
right.
Mr. DeMelfi.
Nice. See, we're working together already. Thank you.
Excellent. So the next thing I'll notice, I have no idea what the underlying substance of this dispute is, but I will let you know that in the interim, while this was pending, the court sent out a notice of intent to enter a court-issued scheduling order. Those, when I issue a court-issued scheduling order, they are significantly compressed in time. And so that order has already been entered on August the 1st. If that time is fine with you guys, great. But if it's not, you should go ahead and make it a priority to get together and figure out what you want in terms of how much time it will take for you guys to actually prepare your case. And then submit a proposed amended scheduling order so that we can actually give you the time that you probably will need to handle this matter. Okay?
Fair enough.
Excellent. Anything else that you need from me, Mr. DeMelfi?
No, Judge, that's all. Thank you.
Mr. Bruck?
No, Your Honor. Thank you.
Okay. Have a good day.
You too.
Thank you.
Okay. Do I have anyone here from Cook's Landing Homeowners Association?
Judge, it shows that Mr. Moore did not open the notice for this hearing.
This matter will be dismissed for lack of prosecution. Ms. Green?
Yes, ma'am.
This matter is going to be dismissed for lack of prosecution because the counsel for Cook's Landing Homeowners Association failed to appear. Do you
Judge,
understand? Yes.
I would like to point out that they did file a motion for default judgment into the record along with the proposed order, but it asks for attorney's fees, which would have required them to appear here. So they were not off the hook for appearing, even though they were never given permission to be excused by the court. So I just wanted to make that, aware.
Okay. As I said, dismissed for failure to prosecute. Thank you. Ms. Green, you may be excused. Have a good day.
Thank you. You as well.
And Citibank versus Bryant Johnson. Mr. Wright.
Yes, Your Honor. Sorry.
If you, so let me, I'll save you a little bit of time, right? So when I was preparing for the hearing today, I reviewed the file and it does appear to me that service was made on June the 11th and filed nearly immediately thereafter. So there's no issue with the delayed date. The answer was therefore due on July the 11th and there was no answer filed. There has not been any answer filed to my knowledge. And therefore, Mr. Johnson went into default on July the 26th. Can you tell me if the requested the relief that you are seeking, is it liquidated, unliquidated, and are there attorney's fees?
Liquidated. So the damage are liquidated, seeking court costs and no attorney's fees.
Okay. And have you submitted a proposed order in Word format to Mr. Freehoff?
Yes, Your Honor. And I emailed it to you during this hearing, so it should
Oh.
be high on your email inbox list.
Okay. Excellent. Okay. And you said you are not seeking attorney's fees, just liquidated damages and the court costs associated?
Yes, Your Honor.
Okay, excellent. Well, it does appear that Mr. Johnson is in fact in default, and that the plaintiff here would be entitled to a judgment, a default judgment, based on the allegations of the complaint. And so we will go ahead and review the proposed order and get it on file for you. Okay.
All right, sounds good, Your Honor.
Thank you. Have a good day, Mr. Wright.
You too. Y'all take care.
Okay, so I think about 6 minutes late, but I've worked my way back to the matter that I expected would take the most time, which was the Fulton County School District case versus SC. Okay. As I understand it procedurally, although it is the petition was filed by the Fulton County School District, it is an emergency motion that was urged by the respondent. Is that correct, Ms. Waldman?
Yes, Your Honor.
Okay. So if you want to go ahead, feel free.
Yes, Your Honor. Your Honor, the question in dispute today is whether the State and Superior Court Appellate Practice and Procedure Act applies to disciplinary appeals filed under 20-2-1160. The consequence of whether that act applies is the question of whether an automatic stay is imposed pursuant to Title V, or whether the State Board of Education disciplinary decision takes full effect, in which case SC, the student in question, returns immediately to her preferred school, Innovation Academy. That's the essence of this matter, Your Honor. The key structure of Article 5, the State and Superior Court Appellate Practice and Procedure Act, is to create a process. That process is called a petition for review, so as to streamline appeals, effectively eliminating what used to be this.
Well, let me save you some trouble, Ms. Waldman.
Yeah.
I'm very familiar with the new Appellate Procedures Act, so you don't need to educate me about that. You do need to educate me about whatever other procedures are in place associated with disciplinary action by the Fulton County school system, because that is definitely something I'm not familiar with.
Wonderful, Your Honor. Important background, though, with the new Procedure Act is that when the legislature enacted it, they painstakingly went through the code and identified 30 plus provisions where they crossed out words, changed the words notice of appeal and put in petition for review, where they added a sentence, that sentence being something along the lines of all petitions for review pursuant to this chapter shall be proceeded in accordance with Article 5, right? When they wanted to do that, they did it. In the filing that I submitted very late last night, Your Honor, because I received a response brief at 4:52 p.m., I included a chart. That chart can be found on the PDF. It is Exhibit 2, page 65 of the PDF. That chart includes every single one of the code amendments that the legislature decided to make. If you look at Exhibit 5, in 2024, the legislature went back at the request of the drafters, and what they did was that they actually struck out petition for review and struck out the language that Article 5 will apply in a different provision. It's a totally unrelated provision to what we hear before today, but when they struck out petition for review, they wrote back the words notice of appeal. The legislative intent as we go through this is to create a petition for review in a whole bunch of places where the certiorari process was ineffective, and to leave in a concept of notice of appeal in other places. Title 20-2-1160, the controlling appellate statute with respect to disciplinary appeals from the State Board of Education, uses a notice of appeal language. Importantly, not only does it use a notice of appeal language, but it also has language within the statute that tells you that only 20-2-1160 is the procedure we're supposed to follow. The school district understood that because they followed the procedure in 20-2-1160. They wrote you a notice of review that they cited pursuant to 20-2-1160. They did not, in that language, ask for a stay. What ended up happening is after this case was filed, my client, in accordance with the State Board of Education decision overturning what was an illegal appeal, illegal suspension of her, tried to enroll back in her in her original school, her school of origin. When she tried to enroll back in her school of origin, they originally put her on a wait list, but then they backtracked from that and they told her, no, you don't get to go at all. Doesn't matter because there is a stay pursuant to Article 5.
So I don't want to get down too far into the weeds of a lot of these issues because I do think that it merits more preparation, more detailed assessment. But I will say this here. One of the things that I was confused from a factual perspective, and again, I'm not familiar, thankfully, with the process of disciplinary matters associated with the Fulton County school system. But one of the things I was confused about is that I understood the discipline that was imposed to have been a suspension for the remainder of the 23-24 school year. And that is over. Granted, there may be a dispute about it, whether that ever should have happened, and that might have ramifications for eligibility to programs, certainly for, permanent records and college applications and things like that. But now we're in the 24-25 school year. And what I am confused about is why would a stay of a disciplinary action that occurred and would have been completed had it been imposed, or assuming it was, back in 23-24 school year, affect the ability of that student to enroll in this school year?
Your Honor, there are two components to the discipline that was imposed. At the local hearing level, the initial stage of the hearing level, there are three stages that have happened so far. At the very first stage, at the hearing officer level, she was suspended through the end of 23-24.
Mm-hmm.
At the local board level, that suspension was modified. It was actually shortened, but it was added to with a permanent ban from Innovation Academy.
Okay.
Innovation Academy it's not a program, it's a school. It is a public magnet school.
Right, but it's a specialty admission type program. Okay.
That she had been attending. She attended through 9th and half of 10th grade year. She had attended prior to this allegation with no disciplinary infractions and a 99.7 GPA. She was attending that program, and it is a unique program. The school district acknowledges on their website, but also in their brief, the uniqueness of this program. The harms of not going through this program, in particular as an 11th grade student, is when they have what is called their Pinnacle program, which is a year-long research project that happens throughout the 11th grade. We do not dispute that she is currently enrolled in a school. She is enrolled in Alpharetta High School. That is her home school. There are wonderful things about Alpharetta High School, but it is not the specialty program that she was attending before this illegal suspension, and it is not the program she wishes to be attending at this time. But for the district's illegal suspension and illegal application of this stay, she would be back at Innovation Academy. And that's the importance of this stay at this moment, because without this stay, she goes back to Innovation Academy, where she belongs.
So next question, and it may result in a transition where I want counsel for the school system to answer the same question, which is without at this preliminary stage unraveling this sticky wicket, right? Does the court have authority to simply say, I'm going to enter it, I'm going to procedurally order some relief preliminarily to the student. I guess my point is from a straight up preliminary injunction type relief, can I waive away the stay for purposes of allowing the student to attend school? I know that is a substantive outcome, but I'm trying to figure out if I even have the authority to do that without unbounding all of this. Is there a stay? Is there not a stay?
I would argue Your Honor has the right to do what I would argue the answer is yes. I think we will get into a fight about, my guess is, irreparable harm on either side. But I would argue that Your Honor does have the opportunity to lift a stay. Again, if we're looking at Title V, the stay provision is all about supersedious bonds, right? It has one word that says something about stays, but it's clearly not contemplated to be something like the education context. There has never, I can't say ever, there has never been a reported decision in Georgia or any other state in the country with respect to a stay of disciplinary hearings at this level. Out of a state board of education level hearing that comes to a superior or court of appeals, I have found 0 cases reported. I have been practicing education law in 18 years in Georgia and 6 before that in New York, and a school district has never before asked for a stay. This stay, quite frankly, Your Honor, is a stall tactic being utilized by school districts at this point because they found this provision in Article 5 that they are utilizing to their advantage to continue punitive discipline against students when they have lost. And it is unfair and it is harmful to students. And this is, to my knowledge, within the last month, number 4 filed by this particular law firm or 2 different school districts. At this stage, all done within the last month. This is a wicket that will eventually have to be unraveled, whether that be going back to the legislature to make it very clear or otherwise. But to me, the legislature was clear. They knew how to parse the code. If you look at the law review article we cited in our brief that was written by the authors of this new provision, they talk about how they painstakingly spent years cataloging every single appellate practice and procedure that existed in our codes. It is unfathomable that they just happened to skip Title 20.
I don't know. I'm pretty familiar with the legislature, and while I've no doubt that they are often working very hard and in earnest to do the complete, full, right thing, things get done in weird ways sometimes, especially on the 38th day of the session sometimes.
I am very familiar with the legislator and how it works as well. We have a legislative clinic within my program, and I'm there all the time. This is not something that the legislator did on the 28th day. As you know, this is a process that was underway for years with the authors of the legislation who wrote the law review article, chief among them, Judge McFadden. They did not write this and pass this willy-nilly overnight. They wrote this and passed this after years of study. They wrote this and passed this after the authors who had written the Appellate Procedure Act Hornbook identified which issues were causing a problem. It was the writs of certiorari that were mucking things up because substantive decisions were not being made.
Trust me. Yes,
terrible.
parsing all of the what's an amendable defect and not an amendable defect it took an excessively long amount of time in different cases.
And that is not what's happening in 1160. If you read the language of 1160, it's clear. again, been doing this a long time. There's never been a case in 1160 where it's just sat and not gone, or we haven't decided issues. 1160 has the following language in it. Where an appeal is taken by the state board shall, right? And then it goes on to a number of things they shall do. But one of them is clearly describe the procedure and requirements for such an appeal, which are provided for in this subsection and in subsection D of this code section. It's a self-contained code section that very clearly tells you what you have to do. And then it embeds the specific notice of appeal it wants. It tells you everything you need to know, and it doesn't use the words petition for review at all anywhere. It doesn't include the words, hey, and the procedures shall be utilized. Are those procedures found in Article 5? They just didn't mean to do it. And then they had a year, and they didn't mean to do it because they didn't go back and fix it. Nobody brought up that this is a problem because it wasn't a problem. Notice of appeal means notice of appeal, not petition for review. And the legislature, the drafters, more importantly, because I agree with you, the legislature doesn't always mean what they mean, but the courts of appeals say they do. And the legislature, the drafters of this were very thorough. Title 20 is not hidden. They hit some of the most unique, smallest provisions, right? They know how to do a control F the same way I do to look for the word appeal and figure out which ones are appealable and which ones they meant to encompass within Title 5. And it's just not there with Title 20.
Okay. Last question. I asked you about what authority I had, because that is one of the complaints that the school board asserts, right? One of the challenges is that essentially the relief you request on an emergency basis is akin to an injunction, which I've mentioned as well. And they have pointed out that there is sovereign immunity, would prohibit the court generally from entering any sort of preliminary injunction against a government entity. What say you on that issue, Ms. Waldman?
So 2 points, right? One, first of all, I'm not even sure they're the right party who's before this court today. The party below is the Fulton County School Board, not the Fulton County School District. Those are 2 different entities. They happen to be represented by the same
district is a municipal entity. The board is a corporate.
I think that is correct.
Okay.
And it is the school board who is the party below. If you read the transmission from the State Board of Education, it actually identifies parties below, parties in this proceeding, and parties below are the State Board, the Fulton County School Board of Education. It is unclear to me, other than, again, that they're trying to get around and play tricks with this court, that why they file under a school district name rather than a school board name. Unclear. I don't know what they're doing.
Perhaps it's as simple as with most corporate entities or quasi-corporate entities, it can only act through its agents, and the board is the agency empowered to take action on behalf of the district. So
unclear. I will leave that for them to explain their authority and their rationale.
Okay.
But again, I think couching this as me asking for an affirmative injunction is incorrect. It's actually asking me to remove their injunction against my client that is illegally imposed, right? They don't get to utilize a stay in a provision that's inapplicable, right? They don't just get to say, you know what, we don't want to do it anymore. We don't have to follow the rules, right? Everything about that is, hey, we don't have to let her in because we have a stay automatically out of a provision that's inapplicable. If in their statement of events in this case, they could do whatever they want, whenever they want, no matter what, and they're never required to follow the law. And that can't actually be the way this happens, right? There's a procedural due process right that my client has to the appropriate necessary steps that happen in a proceeding. Those steps include a process that is clearly laid out in 20-2-1160, including the appellate process here. It does not include a stay. This is essentially telling them you don't get to utilize a provision that's inapplicable to you. It's not phrased as affirmative relief. It's a phrase that, I mean, and I get it. There's affirmative relief we're seeking out of it, but they don't get to throw random provisions out and say, hey, we don't ever have to let kids into school ever again, and then have no consequences of that. I will admit that I am unbriefed on powers of injunction with respect to school districts. I can tell you that there are hundreds of cases against school districts imposing injunctions, although it is unclear to me, again, entity-wise, whether that is a school, an entity, a school board, and how those interrelate within each other. And I believe certainly you can order the school board. I believe you can order Innovation Academy. I believe you can order individual members. I am unaware of the sort of governance structure and how these interplay well enough to necessarily pierce that at this moment.
Okay. Anything else for right now? It's your motion, so I'm going to let you have the last word after I hear from the petitioner, but do you have anything else to add at right now?
Nothing at this moment, Your Honor.
Okay, thank you. Ms. Akins, Mr. Bryan?
Thank you, Your Honor. Bennett Bryan here on behalf of Fulton County School District. What I've heard here is sort of a classic case of attempted burden shifting. Right, the Students' Council at the beginning of this hearing says the issue is whether the state or Superior and State Court Appellate Practice Act applies. In other words, whether we've proven entitlement to a stay. And that's a classic burden shifting technique. The real question is whether they're asking for relief here, whether the student has identified a legal basis for the relief that she asked for. And the answer is no. You asked her what law gives you the authority to enter an injunction against the school district, and she couldn't provide one. That's because none exists, Your Honor. Now, we know from a high-level perspective, Your Honor, I know you're familiar with sovereign immunity. Sovereign immunity requires whoever is seeking relief, the burden is always on them to prove that the General Assembly or the Georgia Constitution itself has waived sovereign immunity for whatever injunctive or declaratory relief or any other relief that someone requests from a school district or a board. They have to show an act of the General Assembly or a waiver in the Constitution itself. That is, in 2014 is when the Georgia Supreme Court originally said that, and it has been reinforced ever since. The Georgia General Assembly got a constitutional amendment passed that waived sovereign immunity for counties and for cities, and expressly excluded school districts and school boards from that waiver of sovereign immunity. So first of all, right off the bat, they're asking for an injunctive relief. Of course, they don't want to say that they're asking for injunctive relief because, then they sort of tacitly admit that they have to satisfy their burden. Instead, what they're saying is, no, we can't satisfy our burden. So we would like to shift the burden onto the school district, but that's just not the way the law works. And the law on this is pretty well settled. But let's look at what the law does say about the particular issue here, whether a school district what kind of action a school district has to take while a student disciplinary appeal is pending. Do you mind if do I have the ability to share my screen, Your Honor?
You do.
Okay, let's do that. Okay, do you see a statutory provision 22-754, Your Honor?
I do.
Okay, so so far we've been talking about OCGA 22-1160, and that does govern what happens when a disciplinary appeal makes it out of the local level and gets to the state board level. First, 754, you see it references 22-160, but this governs what happens before you get to the state board level, right? And I'll point you to subsection C, specifically the highlighted text. It says any disciplinary action imposed by such officer, which is a disciplinary officer, panel, or tribunal, may be suspended by the school superintendent pending the outcome of the appeal. May be. That is obviously discretionary on the part of the superintendent. The General Assembly considered who should have the power to decide what happens to a student pending the outcome of the appeal. They vested that discretion in the school superintendent. That's the first, that's the first clue here. We go over to 22-160. Nothing in here, nothing in this statute, even assuming this is the exclusive statute that applies to appeals of state board decisions, nothing in here says what happens to the student while the appeal is pending. Only here. And it obviously vests the superintendent with discretion to determine what happens to the student pending appeal. And that makes sense. Of course, it makes sense. You know, a school district has power to determine, has plenary power over the educational process. And sometimes, courts are not the best bodies to determine what should happen to a student in the meantime. The school superintendent is. So that's our first clue, is that the only mention of what happens pending an appeal says that it's the school district that gets to decide. Then we go to, then we go back to, here's another provision here would be, I'm sorry, Your Honor, I should have had this one open already, but it is 5-3-17. We go on to the petition for review process. And yes, I'll get to, my bigger arguments about why this should apply, but we don't even need this, but it does support our position. The filing of a petition for review under this chapter shall act as a supersedious and shall suspend, but not vacate, the final judgment of a lower judicatory. So we have two provisions that talk about what happens to a student pending outcome of an appeal. One of them says, well, the school superintendent gets to decide. And the other one says, well, while an appeal is pending in Superior Court, the judgment of the body that's being appealed, their decision is stayed. I'm sorry, Your Honor. I keep looking at the camera on my computer instead of the camera over here, so I apologize for that. So we have two very clear provisions here that say they are not they're unable to point to any law saying that they are entitled to the relief they're seeking. And there are two laws that specifically contradict. We don't have a burden to prove, we don't have a burden to prove the non-existence of our duties, but even still we do here, right? I mean, we point to two specific statutory provisions saying that the relief that they are asking for is not allowed by law. So the next question is, all right, well, does
Mr. Bryan, let me
Yes, Your
interrupt you. So again, going back to my earlier point of the fact that I'm not familiar with these types of appeals. I do a lot of administrative appeals. This is thankfully one that does not come up frequently. But here's where I think I need a little bit better understanding of the procedural posture of the underlying case. Everything that you're saying would make a little more direct sense to me if it was the student that was appealing the outcome. But here it's the state board that's appealing the outcome. And so I'm struggling with, the state board thinks that the decision was not correct, and yet it also wants to get the benefit of enforcing that decision. That's where I'm struggling a little bit.
Okay, Your Honor. Yes, I'm happy to address that. Now, it's just to be clear, it's not the state board that's appealing, anything here. All right, this is the Fulton County School District that's appealing a decision of the State Board of Education. With the State Board of
I misspoke. Sorry about that, but thank you.
Yeah, of course, Your Honor. And what the basic process is this: a disciplinary officer, tribunal, or panel under law makes the decision about what the discipline should be. All right. Then the student has the ability to appeal that decision to the local board. Once the local board makes a decision, either party can appeal to the State Board of Education. Then any aggrieved party can appeal the State Board of Education decision. So what the substantive standards in 1160, and again, what which would also be the same for the petition for review process, is that the decision of the local board is the one that's the focus, right? The on the record appeal is about whether there was any evidence in the record to support the local board's decision. So the State Board of Education is acting as an appellate body when it's considering the local Board of Education's decision. And then this court is acting more or less like the Supreme Court over the State Board of Education, which is like the Court of Appeals.
Right.
And
that part I got. It's just the underlying effect of the school district's appeal. Typically a supersedious would have the effect of staying the execution of a judgment. And
yes,
go ahead.
I completely agree, Your Honor. The supersedious would suspend enforcement of the decision that's being appealed. The decision being appealed here is the State Board of Education decision. The supersedious, and by the way, Your Honor, I'm sorry, I wish I had the written order right now, but the Cobb, I don't know if you noticed that there's the chief judge of the Cobb County Superior Court last night entered an emergency order because they're having huge problems with their filing system.
I am familiar with that, and I was aware that they were having their struggles over there, and yeah, so.
So unfortunately, I do not have the order with me because it's still, because the clerk still hasn't processed it yet. But we had one of these hearings before Cobb County Superior Court last week, and I will say that the Superior Court did agree with us and said that a petition for review appealing a decision of the State Board of Education does act as a supersedious and does suspend enforcement of that decision pending review in the Superior Court. So we already, again, I wish I could pull that up on the screen right now. That would help, but unfortunately, what I'd have to do is I'd have to get the transcript, but you'll just have to take my word for it for now, Your Honor, if you trust me that
I'm willing to accept your representation, Mr. Brown.
Okay, thank you, Your Honor. So we already do have one court that agrees with us on this, but it is true that this is new. The reason why there's no case law on it yet is because the petition for review statute only went into effect a year ago, and so when we talk about whether which one should apply, 1160 or 531, the Tribunal Act or the Superior Court Appellate Practice Act, there's no conflict between the two of them, Your Honor. It's just the 221160 deals with what happens until you get to Superior Court. And then the petition for review process takes over and describes what happens when you get to Superior Court. You can't point me to a conflict between the two provisions. And a court is sort of, in these principles of statutory interpretation, courts should not find conflicts where they don't exist. And there is no conflict between these statutes. 221160 doesn't say anything about a supersedious at all. It says nothing about a stay. It says nothing about a supersedious. Now, we do know that 22754 says that pending the outcome of the appeal, the superintendent has the discretion to suspend enforcement of the disciplinary action. But, we don't have any conflict between the two statutes here. So in order for
Mr. Bryant, for one,
yes, Your Honor.
Can you take down, unless you're going to shoot something else? I've seen a lot of the supersedious now. Excuse me. Has that process, has a request been made to the superintendent, and has the superintendent said yay or nay in terms of, yeah, we'll, allow the student to enroll at Innovation, or no, we will not allow the student to enroll at Innovation?
Right now, our position is that the student can be properly enrolled in her home school, but not at Innovation Academy. And there are good reasons for that, Your Honor. And let's think about them. The Innovation Academy is a unique being that has limited resources. There are only 50 students that can be enrolled there at any time, and there are 50 students enrolled there right now. Resources have been allocated. That's it. So if you were to order right now the district to reinstate the student in this case, then we have to kick out somebody else. Now, that's the type of decision that a superintendent is far better positioned to deal with rather than a court. With all due respect, Your Honor, the superintendent understands the way that these special schools work. And on top of that, she's not being denied an education, Your Honor. She's getting a great education at a great school, one of the best schools in the state. And so to suggest that she's somehow suffering irreparable harm because she's not getting a privilege of attending this, mind you, we're just talking about for now, we're just talking about while this appeal is pending. Because, another thing, Your Honor, you order her to go back to school right now. You later determined that the State Board of Education was wrong. And now, okay, so now another student's been kicked out of Innovation Academy. SC's in there now. Turns out that the State Board of Education is wrong. Now SC is gone again. This student has now been more or less expelled from their school for no fault of their own, while this is pending. This is why the General Assembly has vested the superintendent with authority to make these kinds of decisions of how discipline should be applied, especially where she's not being denied her education at all. She's getting a great one. Mr.
Brown,
yes,
so I mean, from an equity perspective and a balancing of the relative harms, right, which would be a consideration for the court from just a pure preliminary injunction type relief, right? Balancing the relative harms that and et cetera. But I think, again, where I'm still struggling is, I think I understand the school district's position to be that even though the state board said this is an improper punishment or, sanction associated with the behavior that's alleged to have occurred, that by appealing it, you still get the district still gets to enforce the discipline that the state board has said is improper. And isn't the entire point of supersedious, whichever way it works, to say, no, we're going to stay execution of the judgment. I understand in this particular instance, that judgment that is on appeal is the state board's decision not to enforce. But I guess that's really where I'm struggling, is how by operation of a procedural protection of a supersedious or a stay of the judgment, does the school district get the benefit of imposing the punishment that the state board has said is not a proper punishment? That's what I can't figure out. Like I said, it would make more sense to me if it were coming from the student, but coming from the school board is a little procedurally confusing to me from a pure equity perspective.
Well, Your Honor, I think the purpose of the supersedious provisions is to maintain the status quo. Okay, that is, and the purpose of a preliminary injunction, oftentimes the purpose of a preliminary injunction is the same reason, is to preserve the status quo while a legal case is being decided. Here, the status quo is that she has not attended Innovation Academy for a year now, and she's enrolled at her home school in Alpharetta High School. That's the status quo. They're trying to alter the status quo here, Your Honor. And so not only does the plain language of the supersedious statute and not just this one, but any other one, is to sort of stay enforcement, because, we shouldn't be enforcing a State Board of Education decision until we know that it's correct. And that's I mean, that's pretty basic, and it's also the purpose.
But by
is
that
to make the
logic, but by that logic, Mr. Bryan, should we be enforcing the school district's decision until we know that it's correct?
Well, at this point, it is the status quo, and let's remember the General Assembly vested the superintendent with discretion on whether to enforce disciplinary action or not pending appeal. You know, we have to keep that in mind. The General Assembly has already decided that.
Right. And let me also back up, because I asked you a very clear question, and I think you gave me a clear answer, but I still not sure I asked if that process to request the state superintendent to stay enforcement of whatever the decision was of the district had been pursued. And I think you said the decision of the school district was to not allow her to enroll at Innovation Academy. But procedurally, does that mean that there was a request pursuant to that 754 statute, and that the superintendent said, exercising, the authority functionally, that exercising the discretion afforded to me under 754, no, I decline to stay enforcement of this discipline?
That's a good question, Your Honor. I don't know if anyone specifically asked the superintendent. Can I one moment to consult with my co-counsel here on that, Your Honor?
If I might interject, Your Honor.
Yes,
I don't wish to.
Well, I'm happy to let Ms. Akins pop in as long as Ms. Waldman doesn't object.
I don't.
Okay, Ms. Akins?
The student did send a request to the school on this specific issue, and the superintendent heard that request, and the superintendent his decision was that we seek this appeal, and the issue is stayed from his perspective. So he has denied the student's request to attend Innovation Academy, largely due to allocation of resources, staffing, student-teacher ratios, things of that nature. It's a specialized school, and they only have a certain number of resources. And when SC was removed from the program, another student was placed in the school, and they do not have the current space and resources. I mean, there's a wait list of over 60 students to try to get into this school right now. I mean, it is very limited in number as to what they can allow. And the reality is the superintendent reviewed the situation, and that was his decision.
Okay, so
Your Honor,
even though there may not be a formal process, right, or a letter that you could direct me to, your position is that functionally that process has been pursued, and that by electing this appeal process, the superintendent has functionally denied a request to stay.
Yes. Yes, Your Honor. The family sent a request. That request was filtered up through the hierarchy process within the district to the superintendent, and he made his decision.
Okay, Ms. Waldman, hang on one second. I am gonna let her interject here because it seemed like it was on a specific issue.
And it is, Your Honor, and I could wait till my reply time, but 754, I will just note is 100% inapplicable to this portion of the appellate proceedings.
Right.
754 is about,
because we're at the state board level as opposed to the school district.
754 is about appeals until you hit the state board. 1160 is appeals from the state board. That language is very clear. I will do that on I just feel like we're getting down a rabbit hole that has irrelevance.
No, and I've probably invited us all down the rabbit hole. So y'all are just following me if we're going down there. I apologize. But thank you, Ms. Akins, for that clarification.
Well, actually,
Bryan?
yes, Your Honor. I mean, there's nothing that says that provision doesn't apply. In fact, actually, the provision itself says that it incorporates 22-1160 into that procedure. Subsection A, the provisions of Code Section 22-1160 shall apply to disciplinary proceedings under this part, right? Under this subpart. It incorporates 1160. That's how we get to 1160 in the first place, is because the statute I'm citing incorporates it. That's how it gets in. It says any disciplinary action imposed by such officer, panel, or tribunal may be suspended by the school superintendent pending the outcome of the appeal. It doesn't say pending only the outcome of a particular part of the appeal. It says the appeal. This is all part of the same appeal process. That's first. I just want to make sure that that's clear. Nothing in there, nothing in 1160 says that provision doesn't apply here, all right? Because 1160 is expressly incorporated into the statute I'm citing. Second, I would like to address some of the discussions about whether the Appellate Practice Act applies here. Now, first, it's really, again, I know I'm glad that you're familiar with this already, Judge. I have dealt with this in a different with this statute in a different context quite a bit. Before my current position, I was with the DeKalb County Law Department for a decade, and so obviously I've been dealing with administrative appeals for a very long time as well. And I know I've given probably 5 different presentations on this topic. The point is that all of our administrative appeals process have been chaotic for a long time, and it just hasn't been fair to litigants. We would have decisions from a single one. There'd be several different applications to, say, the Zoning Board of Appeals or the DeKalb County Board of Commissioners. And one aspect of the decision would need to be appealed by petition for writ of mandamus. Another one would have to be by petition for writ of cert. Another one would be through declaratory and injunctive relief. Another one would be through through a notice of appeal. I mean, for one decision, there could be 4 different administrative appeal paths, right?
Again, I don't disagree with you. I mean, I think that, as I understand SC's argument, the 20-2-1160 still uses words like filing an appeal, rather than the newly cast filing a petition for review. And I mean, I think, as I understand y'all's position, it's that the procedure is the procedure, and the vindication of rights, the ability to vindicate those rights that's allowed for in 1160. It doesn't matter if you call it a notice of appeal or if you call it the petition for review structures were intended to provide a procedural vehicle, rather than some unique relief that would separately be afforded by 1160, and that if it wasn't changed, that must be something different. I understand that the petition for review was intended specifically to get rid of that smorgasbord of, is it a petition for certiorari? Is it a mandamus? Is it a something else? But really the issue is whether the fact that the language of 1160 wasn't changed, changes what is the appropriate procedural remedy when a party wishes to appeal, not in the sense of a term of art, but in the sense of it wishes to have an appellate review of a decision that was made pursuant to the statute.
Well, I mean, it's true, Your Honor, that this provision was not specifically amended as part of the overall petition for review process. It's true. And that point is well taken. Of course, to your point, the General Assembly doesn't always get it right, or I should say doesn't always conduct an exhaustive review of all laws that can potentially be affected by an amendment. I mean, I'll just remember in an election case I had a few years ago, there was one provision of law that, generally, when there's a tie in election, a tie, means that like, for example, if there's a referendum question, it doesn't go into effect because you have to have a majority of votes. So, but there was some ambiguity in the law about whether a tie meant, the candidate A won or candidate B won, or a referendum went into a place here or didn't go into there. The General Assembly went through through the election code and through local laws and all that and tried to make it clear by saying, in order for a referendum question to pass it, there must be at least, one more than 50% of votes in favor of it, right? But then they missed it in one aspect of the code, and so then I had to litigate that, right? Sometimes the General Assembly misses these things, but what they do to make sure that they anticipate they're going to miss some of these things, and what they do in order to remedy that, and they did that here. It says that all laws and parts of laws in conflict with this act are repealed, right? I mean, and so to the extent that there would be a conflict between the petition for review process and 1160, then the petition for review process would apply. Of course, it's our position. There is no conflict, and you cannot point me to a conflict there, Your Honor. You can't point me to a conflict. No one can, because none exists. Because 1160 is completely silent about what happens to the enforcement of state board decision pending appeal under 1160. It just doesn't say anything about that. So, this court would have to find a conflict there. And what the Appellate Practice Act does is it's very clear. It specifically says that a petition for review includes a petition for certiorari, petition for writ of mandamus, petition for writ of prohibition, or notice of appeal, right? Like, I mean, they specifically incorporated notice of appeal into that. And so they did anticipate that it would cover notice of appeals. They did say that to the extent that any other provision of law conflicts with this, it's repealed. Third, let's look, if you go to 533 subsection 11, I'm happy to share my screen again, Your Honor, if that would help. But it does specifically say in the Appellate Practice Act, it does consider the fact that school board decisions are going to be covered by the petition for review process. I mean, look right here. Look, quasi-judicial decisions, first of all, it covers all quasi-judicial decisions rendered by a state official or board, right? We all can agree that the State Board of Education here is acting in a quasi-judicial manner. I mean, at least the state board thinks that they're acting in a quasi-judicial manner, because we have their letter says the State Board of Education performs a quasi-judicial function when it reviews local school board decisions. So right there, I don't think anybody would argue that the State Board of Education is acting in a quasi-judicial manner. I mean, they're applying a lot of facts. They're applying a standard of review. They're acting as an appellate court. So we know that under the plain language of the statute applies. But now they're just saying, well, but it doesn't apply to school stuff. Then why did they include talking about quasi-judicial decisions rendered by a county or local school system? I mean, it makes no sense to just say, oh yeah, that just doesn't apply to schools. We're going to go ahead and throw in this provision about local school systems, but it's meaninless. It doesn't mean anything, Your Honor. Obviously, by including this, at least suggests, if we're talking about legislative intent, at least suggests that they're saying that under the plain language, this applies to all quasi-judicial decisions of a state board. We know this is a state board. We know it's a quasi-judicial decision. It also includes those decisions that come from a county or local school system, right? And this also, and so we know that it applies in the school context as well. I don't know, they just missed it. You're right. Maybe if the General Assembly decides they want to exempt them, they can. But at this point, we have to read the statutes in harmony with each other. Petition for review process, by its plain language, obviously applies. And 1160 doesn't even conflict with it. So why the court would find a conflict here without any real solid grounds for that, and in violation, or I'm sorry, not why the court, I pardon my phrasing there. It just using, established rules of statutory construction, finding a conflict here and saying 1160 applies and the petition for review process doesn't, when they actually work together quite well. It's just inconsistent with the principles set forth by our Supreme Court. And in any event, again, Your Honor, pulling all of that back, it's not our duty to prove that that there has been a waiver of sovereign immunity. It's not our duty to point to any law saying that we are allowed to do this. I have pointed to those laws, but the duty is on SC here to cite a law specifically authorizing the relief that it asks for. And they just have not done that here, Your Honor. And this is a jurisdictional matter as well. Whether this court can order a state agency, at least as per as a state agency is understood for purposes of sovereign immunity, is an issue of subject matter jurisdiction. This is whether the court has any authority to enter it in the first place. And so, subject matter jurisdictions issues are serious. And
Subject matter jurisdiction, obviously very serious, but and I know that it can have the effect of limiting the nature of relief that the court can afford to, or excuse me, against a government entity. But we're here because Fulton County is invoking the court's jurisdiction pursuant to the petition for review. So presumably, within reason, the court has the authority to order whatever relief is appropriate pursuant to the petition for review procedure.
Well, I agree with that, Your Honor, as far as it goes. Of course, the petition for review procedures does not authorize the relief that that they're asking. And so, yes, we're invoking your jurisdiction here through the petition for review, Your Honor, but we're only invoking it to the extent of that, right? We don't waive our sovereign immunity simply by following a petition for review. This does not now open us to relief that's not otherwise authorized.
Right. I agree with you. I'm just saying that given that the nature of the relief is substantively something that is in fact at issue in this case, I think there's an open question as to whether the court would be prohibited from addressing it, but go ahead.
Well, either way, Your Honor, that's I would just ask you to hold SC to their burden of proving that they are entitled to the relief sought and not pushing that burden onto us, which we do not have. Thank you, Your Honor.
Thank you, Mr. Bryan. I'm sorry. Ms. Waldman?
Yes, Your Honor. There's a lot there. I'm going to try and do it in a semi-organized fashion to the best of my ability. And I apologize if I'm going to jump from topic to topic. Let me start with, I think, what is the easiest one, which is 20-2-754. And let me read that section in its entirety. I know it was up on the board. That section in its entirety says, if appointed to review an instance pursuant to 20-2-753, the disciplinary officer, panel, or tribunal shall conduct a hearing. And then I'll skip forward a little bit. Any decision of such disciplinary officer, panel, or tribunal may appeal to the local board of education by filing a written notice of appeal within 20 days from the date of decision is rendered. Any disciplinary action imposed by such officer, panel, or tribunal may be suspended by the school superintendent pending the outcome of the appeal. That is a provision entirely written for the benefit of students, Your Honor. That decision, as you surmise, right, is about local disciplinary officer decisions, not state board of education decisions. The local disciplinary decision may be suspended by the state superintendent to allow a student to go to school while suspensions are being imposed. Because a student's not appealing, and the school district doesn't have the ability to appeal if no suspension is imposed, right? That's just not, right? This is a, let's let a kid go to school in provision.
Right, but that's not this either, right?
That's not this.
Not an issue where a student is not receiving the public education to which they are entitled if they so choose. She is being educated at Alpharetta High School. She's just not being allowed the privilege of attending a specialty program that she was previously accepted into and allowed to participate in.
Understood, and I will get to that substance in a moment, but procedurally, right, my point is that procedurally 754 is irrelevant.
Right.
What is
I already agree
relevant-
with you. So
Right.
let me, your point a moment ago during some of the crosstalk that I allowed, that applies to decision-making process from the school up to the school board, I think is well taken. And so go ahead.
Let me put the next important part of that though, which is 1160 doesn't have a corollary. 1160 does not say a provision of the state board of education may be stayed by the state superintendent. Right? I think that's an important identification and omission, right? There was no, again, statutory intent to talk about, consider, contemplate stays when a state board of education decision is issued. That's why 1160 is in conflict with Title V. Right? Title V imposes a stay when there is a petition for review. Petitions for review are different than what is laid out as a process in 20-2-1160. There are a lot of differences between the process in 1160 and the process in Title V. There are timeline differences as to when the state superintendent needs to transmit a record. There are notice differences. The form, as we identified in exhibits attached to our filing, the forms look very different, right? The notice of appeal just says, I hereby appeal, whereas the petition for review has a whole bunch of language in it. Article 5 has a response procedure. I will, in fact, ask Your Honor at the end of this if I need to file one pursuant to Article 5. Title 20 doesn't. There is never, again, in the history of Title 20 been a response pleading because that's just not contemplated by Title 20. There are structures in Title 5 that are just fundamentally different.
Right, but
And
isn't
1160
at
says
least-
the words, the procedures are here.
right, but isn't there at least some? I one of the things I noticed in reviewing 20-2-1160 is that while you could argue that a quote notice of appeal is a term of art, distinct from a petition, that I think my review of the language, correct me if I'm wrong, that it doesn't use the phrase notice of appeal. It says you may seek appellate relief or you may file an appeal. And then it says, and the appeal should be in this form, which doesn't necessarily, other than some of the different response procedures, right? I mean, the basic petition is the same as a notice of appeal, which is here's what I'm appealing. So does the fact that, to Mr. Bryan's point, that the 20-2-1160 doesn't actually use what might be characterized as a term of art of the phrase notice of appeal, but instead just sort of talks about appeal rights generally, there's no dispute here because the petition for review is simply a procedural structure by which one vindicates the appellate rights that are afforded to them in this substantive statute.
Except, Your Honor, that 1160 uses the words, right? So, and I think that's right. I think it's actually contrary to Mr. Bryan's argument, because Mr. Bryan goes back and says Title V actually uses the word maybe notice of appeal, although that gets confusing because clearly they struck out the language in their cleanup bill, meaning notice of appeal to be something different. This isn't even a notice of appeal. This is actually entirely different. And then 1160 in subsection C says, shall clearly describe the procedures and requirements for such an appeal, which are provided in this subsection and subsection D. That's a self-contained provision. It doesn't say which are provided in this subsection and subsection D, and also, by the way, go refer to Article 5. It doesn't do that. It says, like, we right here tell you how to appeal this process. You appeal it, and the notice that's given by the state board, which is embedded in Mr. Bryan's appeal, says nothing about Article 5. It says nothing about you get a stay. It says nothing about appeal rights. It says nothing about responses, right? It says, here's the procedure. Send the Superior Court this, I hereby appeal. Wishy-washy, like it's a 2-sentence letter that says, here, go start the process and tell the court you wish to appeal. And that process, again, unlike the previous writs of cert and writs of mandamus and all of the other things, that process worked. There has not been a school discipline appeal that just sat there and didn't get decided on its merit, right? It was a process that was not broke. It was not a process that was intended to be fixed. And so I would assert they are in conflict, right? The district continues to assert that we're trying to burden shift, but I would assert it is them that's trying to burden shift. They are asking for a stay. That is an affirmative ask, right? They didn't actually even ask this court. They are asserting they have the right to a stay just by nature of giving Your Honor jurisdiction over them by filing an appeal. You are right.
as
perhaps
I've
this is
said,
best
yeah,
law.
as I've said a couple of times, the reason I'm struggling here is Ms. Waldman, if the decision of the state board had been to approve the decision of the school district.
Yep.
And you had filed an appeal, you would be seeking to stay the execution of the state board's decision, and by extension, the state discipline or the school district's decision to enforce the discipline. While
honestly,
the
Your
appeal
Honor,
was vindicated.
I mean, honestly, Your Honor, when the state board rules in favor of the student, there's no further appeal. When they rule against the student, they've already been suspended. And so frankly, that reverse doesn't happen. Right? So when they rule against the student already lost below.
Right.
And below and below. There's never a stay request because the status quo is always that they're out, that the discipline is being imposed. So there is no flip. This stay moment that the district is asking for only
but what
benefits a
I
school
understand
district.
historically, Ms. Waldman, what I'm saying is that if the petition for review is the appropriate vehicle and that comes with it a supersedes a stay, then wouldn't a student have the ability to stay enforcement of the discipline if that's in fact the judgment of the state board?
No, Your Honor,
While they
because there's
vindicate their appellate rights?
I don't think they get to go back 2 levels. Right. So the decision and maybe you're telling me I can, but I think the answer is right. The decision, the status quo at that point will be that the child is out. And because the status quo at that point will be that the decision of the local board will have been enforced. And then the state board has affirmed that decision. I am struggling to see a circumstance where a student would want to stay as they go through this process because their status quo is almost always they're out. It is only when the student wins where somebody wishes to change the status quo from the state board level. So this is in essence a district trying to get a second bite at extending discipline when they lose. This is the district saying, hey, you know what? The state board lost. Even if they don't have a valid substantive argument, they get to discipline. If we put this in place, they get to extend discipline by however long this briefing process they think is necessary takes. And then they get to appeal it to the Court of Appeals, which means they get to never lose.
Right. Well, so
they work, they never lose.
Right. So going back to my original statement about being a little unclear on how this internal disciplinary process works. But what I'm imagining, and please tell me if I'm wrong, a situation in which a student is, for example, a disciplinary decision at the school level is to expel a student from a school. And the student files an appeal, and pending that appeal, the student says, please don't expel me because I think I have a decent, and the school says, okay, we're not going to expel you because that's, a pretty harsh remedy. So we'll let this play out. And at some point, let's say that every decision says, no, the student should rightly be expelled. The student should rightly be expelled. But if no one ever executes on that expulsion, pending appellate rights, and the student files an appeal using the petition for review procedures, wouldn't that student also be entitled to stay execution of the judgment, which in that case would be a judgment ordering their expulsion?
In a hypothetical law school exam question, the answer is yes.
Okay.
In the real world, right, when a school district is expelling, I would say the chances of a state superintendent issuing and implementing a stay pursuant to 754 is nil, less than 1%.
Right.
I mean, closer to nil than 1%, right? Because when you have a decision to expel, the superintendent isn't going to be like, you know what? I know I'm up for election. let me put this perceived dangerous student back inside a classroom. It just doesn't happen, Your Honor, right? It's so yes, in your hypothetical, if I put it on my law school exam in education law, this law, we would absolutely sure it could work that way. But that's not the practicalities. The practicalities is that this is a mechanism by which the district gets to continue to punitively punish when they lose, right? The first time, keep in mind, that the first time somebody who is impartial, truly impartial, decides this decision is when it is in front of the State Board of Education. The local Board of Education hearing officer is a school district employee, is a district employee. They are impartial such that they don't have prior notice of the proceedings, but they are not outsiders. They are not independent. They are employed by the school district. The school district is clearly the school district who has its own motives, thoughts, processes, right? They are not independent functionaries. The first time somebody who is truly an independent is when it goes up to the State Board of Education in front of a State Board of Education hearing officer and signed off on by the State Board of Education itself. And that's where we are now with this case, right? I don't want to get into the facts. I don't want to get into the issues. They are, I don't think they are complicated, but they are, right, somewhat in dispute. But there was press about this case. I think this is a district saving face and scapegoating. We can talk about that as we get to the underlying merits, but what they are doing is again punishing when the procedures have played out against them. And unless we either decide this against them now on the procedural issue or truly expedite a process, right, which is my alternative relief, my very, very alternative, right? I think they don't get the stay. Perhaps we consider this not injunctive relief, but a mandamus, ordering an agency to a governmental agency to follow the law, which is the State Board of implement the State Board of Education, right? If that is an easier framing, right? That if Title V doesn't apply, the State Board of Education order is the law, and we order them to follow that law as we go through this process. We could have months, and I know they keep trying to. They're playing both ways, which is Innovation Academy. There's no irreparable harm because there's nothing special about Innovation Academy because she can just be fine at Alpharetta, while simultaneously telling you how important and special Innovation Academy is. And the truth of the matter is, what we're doing here is significant emotional, if not educational, right, harm to a 16-year-old girl who has been deemed innocent of the charges, right? And that's we can't lose sight of that. This is a procedural exercise for me and Mr. Bryant, but this is not a procedural exercise for my client, SC, who is.
So forgive me. Full disclosure, I am the mother of 3 teenage girls, okay? So I certainly understand the risks, the danger, the importance of allowing students to have the benefit of all the educational opportunities that might be afforded by their school district. So you don't have to sell me on that one because I understand it.
Right.
But
and ripping them away from their friends and ripping them away from the, right? And
but I do think that ventures, except to the extent that you're talking about irreparable harm, right? It still ventures into the substance. And I understand that that's not your preferred outcome, but one of the issues, right, is that it is to simply, I mean, the entire purpose of a petition for review, whether it is under the new appellate procedures or whether it is under the 1160 procedures, is for a record to be provided to the fact finder and for the court to have a full, final substantive hearing in an efficient way where the court can fully vindicate all of the rights that are presented to it. And so while it is less than ideal that the student is not able to have the benefit of Innovation Academy right now, given some of the difficulties associated with bumping another student versus adding an extra student, et cetera, how, reasonably speaking, how quickly could we expedite it so that the parties would just have the benefit of a substantive ruling? I understand that doesn't address your concern because, as you said, if I were to rule against the school board, they may very well file an appeal, and then, you know, all bets are off in terms of how long that might take. But what are your thoughts on, like, can I just set a hearing and, you know, 30, I've already got the record, set a hearing in 30 days and let's have a full blown substantive hearing on what the record is and determine, you know, who.
And I think, well, to let me quickly address, I think they are overblowing the size issue. Just as obviously, I think that is an overblown. Waivers exist. They are applied all the time. I think they can add a student, but also they shouldn't have given our spot away, right? This has been a decision that came down in June. They've known this appeal process was going through. They've known the likelihood of this. Were they never anticipating letting her back in? Because that's clearly what they're trying to tell you, is that they never were going to let her back in because they were always going to risk another student's spot. And I think that is a disingenuous, irreparable harm that's being put forth by the district, but that also shows their true intent. On the how quickly can you have a hearing, Your Honor, we fully briefed this below. I fully briefed this. Ms. Akins fully briefed this. She handled the trial below. I handled the trial below. I don't have any reason why you can't handle this on Friday of next week.
Okay.
I don't have any reason why you can't handle this tomorrow. I'd be happy to brief this weekend, Your Honor. We are ready and we can go forward. The record is short. I
figured that out already. So
there is a 4-hour disciplinary hearing, I think less than that, hearing that happened down below. There's a transcript. It's a couple of 100 pages. It is easy to read. I know the merits. Ms. Akins knows the merits. Mr. Bryan can learn them pretty quickly. They're pretty short. I've written 2 full briefs below. Ms. Akins has written a brief below. This ain't hard. We can solve it. We could have solved the merits today. We can certainly solve the merits in a week.
Ms. Akins, what are your thoughts? Or Mr. Bryan, what are your thoughts on expediting a substantive decision process here?
I think an expedited decision process is fine. I think 1 week is somewhat unreasonable because while we have briefed the facts below, we have not briefed our concerns and the specific issues with the State Board of Education decision. That is not something that has been briefed. I would presume that if we submit a brief outlining our concerns, issues, and the legal problems with the State Board of Education decision, that Ms. Waldman would want an opportunity to respond to those specific points from us. And so I do think that the district should have an opportunity to brief the issue, that they should have an opportunity to respond, and then we can have oral arguments on the merits. That's typically how this works out. I think within 30 days, absolutely. I think within 7 days, probably not. That just does not seem to make sense to me just from a briefing sort of back and forth opportunity. But I'm happy to, somewhere in between the two of those, I think is very reasonable.
Okay. So, realistically speaking, if we're going to do that, whatever I do today, right? I do think that it makes sense to expedite the substantive handling of this matter in terms of complying with the statute and addressing what is the real issue, which is the merits of the underlying decision by the school board and the state board. So practically speaking, I'm supposed to start a 3 co-defendant gang murder trial on Tuesday the 13th. Now, having said that, I do have pockets in all that time, one that may always resolve, one never knows. But also I do have pockets in there where I can fit in a few hour argument on a morning or on an afternoon where I either bring the jury in late or send the jury home early. So here's why I say all that. I also typically have a motions calendar the first week of every month, as I'm doing this week. And so what I would be able to do potentially is set a hearing on this matter, depending on announcements for how long you think it would take. Sometime the week of the 26th of August, or sometime the week of the 3rd of September, which I'm not saying the 2nd because the 2nd is Labor Day. And that would depend on the time announcement the parties would give. But what my intention would be to set it for hearing that day. And then we can reverse engineer whatever the party's briefing is going to be on those issues so that everybody has a chance to get me that information that I need before then. I would probably rather do it sooner rather than later because I do think that the resolution of this issue, at least at my level, is encouraged, if not required, by the statute. So what are your thoughts, Ms. Waldman, if sometime the week of the 26th would be doable from a, let's set a hearing for, say, like I have hearings already on the 29th. So theoretically, I could have hearings on the afternoon of the 29th or the morning of the 30th. If you're thinking this is a 2-hour, 3-hour, 4-hour, I don't know, substantive hearing. Ms. Waldman, what are your thoughts?
I don't know why it would be a 2, 3, or 4-hour substantive hearing. Quite honestly, this is an oral argument. I think both Mr. Bryant and I, or Ms. Aiken and I, could probably argue for the rest of our lives. But at its core,
all good lawyers could. So.
But at its core, it's a legal argument on sufficiency of evidence. It is a record. There's no, we are not allowed to introduce new evidence. There's no exhibits to introduce. There's nothing, I mean, other than perhaps statutes and charts, right? But there's pictures, but there's nothing new. There's no witnesses. We're not allowed to bring witnesses. I would probably, I will tell you that when arguing below 20 minutes was too short to cover all the issues, I would probably ask for about 40 or 45 per party.
Yeah, I would minimums probably want to set it for 2 hours.
I think that's right. If you gave me 5, I could probably fill them, but I don't.
That's true. We all could. I mean, because as lawyers, why would we say it one time when we could say it 3 times?
Right.
So.
Absolutely.
And why would we stop it back and forth when we don't have to?
Exactly. And then the judge interjects and makes everybody mad because they ask all kinds of stupid questions that you have to stop back up and educate me about. Ms. Akins, do you think 2 hours is reasonable? And do you think the week of the 26th is reasonable or doable?
I think, yes, Your Honor. I think 2 hours is reasonable. I have no problem with the week of the 26th. I will note that I have, I'm currently 30 weeks pregnant and I have doctor's appointments almost the entirety of the 30th. I try to line up all my appointments on one day just to make scheduling in my life easier. So I would ask not for the 30th, but I can make myself available literally any other day that week. You just tell me when it works best for the court and Ms. Waldman.
Okay.
And I have a specialist at trial on the 28th that may or may not get bumped, but everything else on my calendar, Ms. Windus, who is here, can handle, but not that trial. So.
Okay. Well, then here's what I might do if that's acceptable to everyone. I might target my calendar for Monday the 26th or Tuesday the 27th. And I would typically do it at say 9 a.m. because that way, if I do still have a jury, I can just have the jury come in right after lunch and resume with the trial. And I would set aside 2 hours ish. That way it gives us also a little wiggle room if we need some additional time. Okay. So as I mentioned at the beginning of this hearing, it's a fairly sticky wicket that I don't necessarily want to unravel if I can avoid it right now with what I think amply demonstrated is some of my ignorance of the substantive underlying issues. I will say this. I think I made that point when I was talking with Miss Waldman. Why is my brain just stopped? Sorry. I think I made the point when I was speaking with Miss Waldman earlier that my review of the 1160, subsection 1160, is that it is not directly in conflict or directly at odds with the petition for review process. And I think that the directives that we receive from the Court of Appeals are routinely that we should read statutes. The rules of statutory construction tell me that I should read statutes in ways that they coalesce with one another and can coordinate. And I don't think it's very hard to understand that 1160 while it may have previously provided the procedure, it no doubt also provided that there was a substantive right of appeal. And the fact that there is now a new consolidated appeal procedure doesn't change the fact that 1160 provides the substantive right to appeal that decision. And to the extent that that means that under the petition procedures, the school would be entitled to some delay or stay of enforcement of the judgment that's on appeal, then I think that's what necessarily follows from my understanding of how 1160 works in the context of the petition for review statute. Having said all of that, I think I've made plain that it does bother me, Ms. Waldman's characterization of this process allowing the school district to have the benefit of their discipline essentially indefinitely while they appeal. I find that troubling, and I'm struggling with why that would be substantively appropriate, which is why I went down the rabbit hole with Ms. Waldman about the ability of a student to get the same benefit. And I think that's the wicket that's sticky that I'm going to have to figure out as we're dealing with all these issues. But for now, from a preliminary perspective, I don't believe that 1160 creates some alternative procedure that would take us outside the realm of the petition. And beyond that, whether I have the authority to enjoin the school district or not, at the end of the day, as a matter of equity and the maintaining of the status quo, it does appear to me that, at least for now, particularly if we're going to proceed on an expedited basis to a final substantive hearing, that the status quo here is that SC is enrolled in school and receiving the education to which she is entitled. And we will determine whether she is also entitled to be returned to the school that she was accepted to and perhaps wrongly dismissed from when we decide the merits, or when we get to the merits. And so that's going to be my ruling for today. I feel like it's a little bit all over the place, but I appreciate the kind lawyers educating me about, like, as I said, what I've sort of amply demonstrated is a lack of knowledge about that school board procedures. But I do appreciate your patience with me and your time. And that is going to be my ruling. And then what we will do is issue a notice of hearing. It will be a final substantive hearing on the merits. The parties, I would suggest, I don't know if I need to give you a full briefing schedule. I will if you want me to. But what I would be expecting is something, perhaps the week of the 19th that was, cross briefing substantively. And then if anybody wants to reply sometime at the end of that week, I think that's doable. But again, I feel like you guys probably do this more than I do and don't necessarily need a scheduling order for briefing schedules. But again, if you want one, I'll give you one. Ms. Akins?
I mean, I think Ms. Waldman and I can work out a schedule that's fair for both parties. I don't want to speak for her, but I've worked with her before. And I think now that we know kind of the date of the hearing and today, we can work something out.
Ms. Waldman?
I would agree that we could work something out. I would like guidance from the court on two things. One would be the last day for filing a brief, right? So if you can give us a sort of end date on you, if you're giving us, when do you want us to be finished?
Well, what I want is the briefing to be complete and emailed to me no later than the 23rd. And what I'm anticipating is that if the parties are filing substantive briefs and then wish to reply or respond to those substantive briefs, the 23rd would be the last day to do so. And the main thing is, because of the way our system works, you're going to need to make sure you email me those things. Because, for example, the response brief, I actually saw the reply brief that was emailed to me that is still not part of the record before I saw the response brief to which that reply was aimed, because the response was not yet docketed until late last night. And I don't think that at least I couldn't find it, that I got a copy of it by email. So please email me any briefing that you do. And we will make sure that we are on top of the briefing.
And I believe by you mean Mr. Freehoff, is that?
Yes, Mr. Freehoff.
He came on just to make sure we knew that.
Yeah.
Yep.
And I also want to point out that the response and the reply are now in the record. It happened pretty much while we've been having this hearing today. So like Judge, you wouldn't have had it, but I just didn't want the attorneys to freak out and go, my God, I thought it was in
Oh,
there.
no, I know it was there. I saw it this
Okay.
morning when I was calling the calendar, the response. The
Okay.
reply I had not seen as having been docketed, but it may have been docketed this morning while we're in hearings.
It has, so, okay.
Okay.
And if I might have some guidance again on applicability of Title V, are you anticipating a response from me?
So, I can't give anybody legal advice, Ms. Waldman. Right, but
Are you telling me Title V applies?
Right, but to the extent that you've not filed a motion to dismiss saying that it's not an appropriate procedural vehicle, then I feel like we should follow the procedures that have been invoked by.
Well, I will note that it's unclear if they invoked it, other than by me saying they implicitly invoked it by not letting her in school, because their notice was just under 1160. They had not actually invoked Title V at all until I invoked it for them.
Well, like I said,
I will file a reply.
I can't give anybody legal advice. So, but no doubt both of you are, all of you are quite capable attorneys. So I'm certain that whatever y'all do will be the right thing. Anything else, Ms. Akins, Mr. Bryan,
Nothing from the district.
Ms. Walton?
Nothing else.
Okay. Thank you all. Have a good day.